We are back now. Have you ever thought about what you're leaving behind for your family and loved ones when you're gone? Trusts and wills can be uncomfortable to have to talk about with family. But here to help guide us through is Lashandra Peoples-Johnson from Johnson Cephas Law here in Tulsa. Good morning.
Good morning.
It is a tough conversation. Nobody wants to think about them being gone.
Yes.
But so many families have worked so hard for their stuff. When it comes to inheritance, don't people want to protect it?
Yes, so a lot of times people, like you said, avoid the planning of their estate because they attribute it to passing away, and people don't want to think of that. But there are a lot of reasons why you should definitely do estate planning and go ahead and plan that out.
Well, we'll talk about that. I want to first know, if you have no will, no directive, no nothing, and you pass away, what happens in Oklahoma?
The state decides. So if you pass away without a will or a trust, then the state will distribute your property to your heirs. And so there are general rules that they go by. For example, if you have a surviving spouse and child, it would be distributed differently than if you have neither, but you have a sibling or a parent. But either way, your preference is not heard. It's strictly by these rules.
And that takes away what your wishes and wants and desires are. I mean, it really is the worst case scenario.
Yes.
So explain to us the difference between a will and a trust, because some people think they're interchangeable and they're not.
They are not. So a will is a written instrument that provides for the disposition of your property after death. So in Oklahoma, if you're 18 and have a sound mind, then you're able to dispose of your property through a will. A trust, on the other hand, ensures that your assets are managed both during and after your lifetime.
Now, what would be the advantage of having one over the other? Is there a feeling like, for me, like I have a family, we went the trust route. That way, even though I'm alive, there's a lot of stuff that we can navigate and make sure it's protected?
Yes, that's a very good question, and that's often a question that I'm asked. So when it comes to a will, the primary benefit that people see is that on the front end, it usually is less expensive. And that's because there's usually not action that you have to take after it's signed, and it's more simple to create. However, there are several advantages of doing a trust over a will. So one that comes to mind is that if a trust is created and funded properly, then it avoids the court probate system, which means that when you pass away, your property is distributed quicker and is less costly on the back end. Mm-hmm. Another advantage is that it is private. So with a trust, it's not captured through the court system. If you have a will, then you typically have to say what property you have and the value, and that's public record. People can see that.
Interesting. Now, some people may say, I really don't have a lot, or why should I even consider this? What do you tell those folks?
So contrary to popular belief, you do not have to be wealthy or elderly in order to plan for your estate. If you have a house that you own, or a car, or even if you have money in a checking or a bank account, savings account, then you have an estate. And regardless of how modest it is, then you can make those decisions, and you have the right to make those decisions. And the most important thing to know is that if you do not make the decision, the state will, and it will not take into account your preferences.
All right. All these, lots of questions, a lot of details. It's probably advisable to talk with an attorney.
Of course.
Preferably one that kind of, that's what they focus on. Very good. Well, we appreciate Lashandra being with us today. We'll see you next time.